Hi again, people. Okay, day 13 of the Karen trial. This is interesting because the other day I thought that the defense was dancing around why she turned in the photograph a year later. And if you watch the testimony, oh, you know what? I should turn the light on. If you watch the testimony, he was saying, why did you wait a year? Implying that she hid it and then decided to turn it in for no reason. The reason, and he knew the reason she turned it in was because the picture that was causing this guy to get harassed and called and chased and photographed and called a liar and said he was in the house when he killed him, all that, this girl felt like she had to come forward and go, look, I got a picture that we took and I took him home and I have text messages. They are harassing. She tried to do the right thing when she contacted them, but they didn't want to let that in because it lets in the harassment. So what the defense did was walk around it, imply that she was somehow covering up, which to me opened the door for the defense. One time when the door was open, and I remember this one attorney was freaking so mad at me because his client had a felony arrest prior to this case. And because it didn't directly apply to this case, they said we couldn't use it. And it was a felony involving, I think, violence. So his attorney didn't want to put in. The defense, the judge, and the prosecution all agreed it wouldn't come in. So as a witness, I know I can't bring up other people's or their criminal records unless the defense asked directly or unless the prosecution asked directly. So this attorney, when I was testifying, was like, didn't you bring your entire team, because we went to arrest him at his work. We knew he would be there and he was on the run or something, and we went in there and we had our vest on and we hooked him up. And the defense was trying to make it seem like, isn't it true that you went in there and brought all these people just to embarrass my client? And I went, no. Isn't it true that you don't like my client and that's why you brought all these people? No. And so he kept badgering, and finally at one point he goes, well, then why did you bring all these people? And I went, because he had a prior felony. Objection, Your Honor, he knows he can't say, and he went all off and everything. And the judge said, you opened the door. You asked him why he did it, and that was part of the process. When I bring multiple people, it's like, okay, do I need one or two people? Is this guy violent or not? Is he likely to resist? Is he likely to run? Does he have prior felonies? Does he have prior felonies with violence? In this case, it was yes, so I brought my team. It was, whatever the task force was, 5 of us, 4 of us, whoever was working that day. So we went and arrested him. But he wanted a mistrial because the jury heard this. So then he had to go back and clean up in front of the jury and bring in his client and put him on a stand and say, isn't it true that you had a felony? Yeah, and wasn't a misunderstanding, and didn't you take a plea deal, and you didn't really do anything, and blah. So he had to clean up his client. His client was found guilty, and I'm sure if the client paid, he appealed because of that. In this case, this attorney was implying that she turned in this photo because she was involved in a conspiracy and hiding it. That's opening the door for the prosecution to say, why did you turn in the photo? And the reason she turned it in was because the guy was getting harassment. To me, it opened the door. Other people in the comments of my video was saying it did not open the door and the judge shouldn't have allowed it. Well, now we're going to hear from both parties on why the door was open and why the harassment was let in. And then you can make the decision.
Wanted to see me in Sidebar?
We don't need to be seen at Sidebar, Your Honor, but I do need to be seen about an issue from yesterday.
You'd like to be heard?
Well, yes, I would.
Okay, I'll hear you. What is it about?
Your Honor, we are...
So when she goes, you'd like to be heard? Okay, I'll hear you. This is basically, okay, I'll let him check the box. He has to get it on the record that he objects. He has to get on the record they disagree. He has to give her a chance to rule on it. And now, when he appeals, if she's convicted, which I think she will be, if she's convicted, well, maybe she won't be. I don't know. But when and if she's convicted and he appeals, he will say the jury was tainted because of this testimony, and that's why they convicted her and he wants a new trial.
Not only renewing our objection to the alleged harassment evidence that came in yesterday, but we're specifically moving to strike that testimony.
Notice he says alleged harassment.
And specifically asking the court, before we get started today, to instruct the jury that they are to disregard that evidence. And I wanted to point out to the court that it is our view we didn't even come close to opening the door to that evidence. I had just asked the witness if she had turned over those text messages to the state police when she spoke to them on August 25th of 2023. I've asked every witness when was the first time that they spoke to the state police. That was the first time Ali McCabe spoke to the state police. None of that conversation had anything to do with harassment whatsoever. It was strictly related to the death.
See, I disagree. I think he implied in his questions led the jury to believe that she was involved in the cover-up, and she waited a year to suddenly just turn these in for no reason. That was his line of questioning. That allows the prosecution to let her say, what he's implying isn't true. Why did you really turn it in? And that's where the harassment. I think the door was open personally, but there's other people that don't.
Death of John O'Keefe and the investigation of John O'Keefe. I stayed completely clear of any discussion of harassment whatsoever. I only focused on the federal grand jury and the approach by the state police on August 25. I opened no door. I didn't even approach the door. And yet that evidence came in. It led to a moment where, that Mr. Lally, I believe, has been waiting for, which is for a witness to break down on the stand and feel sorry for themselves to gain sympathy before.
So, and this is true, all prosecutors like if you can tug on the emotional strings of the jury. And her testimony to me was somewhat doing that. Not that it was intentional. I don't think she was faking crying. I think she's been subjected to a lot of mean, harassing things. Her family has. They sold the house. They've probably gone in hiding. They had to hire attorneys. They're in the limelight. Their life has been turned upside down for the last year or two because somebody was killed in their front yard. And according to them, they had no clue. They didn't do it. They weren't involved. And now they're getting screwed. I tend to agree with them from what I've seen.
This jury, it was prejudicial to our client. It's prejudicial to our defense. It is error, and we're asking the court to correct it.
So when he says it's error, he's basically saying, Judge, you messed up, and you need to fix this. Now, if the judge says, I agree, it was error, and I will instruct the jury, he will still appeal on that because there's the term that you can't unring the bell. Once you ring a bell, the jury hears something, you can't unring it. Even if you give them a discussion, even if you say strike that, even if you say objection. And he's done this throughout the trial. They have asked numerous questions they know they couldn't ask. The prosecution objects, and the judge sustains the objection. He has done this throughout the trial. So, whatever. It's a game.
All right. What do you say, Commonwealth?
Your Honor, counsel absolutely opened the door as far as the questioning was concerned. It was not just the characterization of the questioning is just simply inaccurate. As far as the
characterization of the questioning, that's the way he's saying. What I'm saying is he implied and led everyone to believe through his line of questioning that she suddenly found these photos and turned them in for no reason.
The questions that were posed to the witness, it was more geared towards why, implying that the witness only provided this after testifying at the other proceeding or being questioned about it in that environment, and that's the only reason that she had these messages, and why hadn't she turned these messages over earlier? And that is in direct response to the harassment that that witness and her entire family, as well as Mr. Albert, had sustained as a result of actions by several different parties, including counsel. So for those reasons, it was proper. There was nothing, I don't think it was more than 5 minutes of testimony concerning it, and it was because counsel opened the door to it.
Okay, thank you. All right, so Ms. Gianetti, I remember clearly the lines of inquiry that you initiated. So I disagree with you in the strongest way possible. You've made your record. Your motion's denied. Okay, so let's bring in.
So you notice it was like, okay, thanks, Your Honor. I got it on the record. I can appeal. I don't really care what you rule. And they don't. They just got it on the record. So this kid's testimony was pretty interesting. Let me go back to what. They really tried to paint him because they showed some photograph of him in a bar that his knuckles were bloody. And the defense did a pretty good job at shaking this witness up. I didn't buy any of it. I saw it all has stupid lawyer tricks. But the guy said he fell and his knuckles were skint and it was a month. The knuckle, for somebody that understands injuries, those knuckle things were recent. They weren't a month old by no means. And he tried to make it seem like this guy was fighting and he's never been in a fight with his brothers. And then he said, have you ever boxed? And the guy goes, no. And he goes, have you ever worked out? Yes. Ever punch a bag? Oh yeah, I punch a bag at the gym sometime. Isn't that boxing? And the guy's like, no, I wouldn't think so. But he kept asking it and the prosecution didn't object. And the kid ended up saying, yeah, okay, I guess it's boxing. So from an unexperienced person that doesn't understand lawyer tricks, the jury may think that this guy's lying. Me personally, I don't think he's lying. I got no problem saying he's lying. I got no skin in the game in this, but I don't think the kid's lying. I think he's being honest, and all of this was just doubt. Let me bring up the grand jury that he can't talk about. Let me bring up things that we can't talk about. Let me make the prosecution object. Anytime you're watching a trial and there is a bunch of sidebars, you know there's shenanigans going on. And it's either the defense or the prosecution, but one of them is trying to pull something. And this judge had to stop the defense several times and have sidebars. And then when they came back, they approached a different topic than they were before. That tells you they got told, knock it off. But the jury doesn't know that, so if you don't understand that, you're going to miss that. So they just broke for lunch, and we'll see how this goes. So this was a good testimony. If you want to watch good testimony on this guy, this would be a good witness to go watch. They are really beating this kid down over a couple videos where he kind of said, I'll mess you up or I'll knock you out, and he's holding a beer and he's with his buddies and he's talking smack. And the internet's forever. And they got this clip, and they're making him look like this violent guy, even though he's testified, I've never been in a fight except with my brothers. And I punch a bag sometimes for cardio. But the defense, I thought, was given a lot of leeway to kind of badger and repeat and ask the same question numerous times, and nobody objected that it was asked and answered and to move on. So I think they made this guy look a little bad. Did they convince me that he's lying? No. But, you know, because he's a young kid in his sophomore or junior year talking smack with a beer, I think they were able to probably convince some of the jurors that he may not be truthful. I don't believe that, but I think they did do that. Okay, so the defense came back and did a pretty good job at redirecting and cleaning up all the damage that the defense did. Prosecution asked good questions. He gave good answers. And in my opinion, he cleaned up. If the jury was skewed before, I think he probably cleaned it up. Like I said, this would probably be a good little interview to go watch if you want to see how a defense attorney can manipulate and really attack and shake somebody up, and then how the prosecution can kind of come back and clean it up. This is a pretty good example of that. The defense is taking advantage of this young kid. If a defense attorney tried that on me on a stand, it wouldn't go good because I know how to answer, and when he opens the door, I would be saying things that he wasn't trying to get me to say. He was able to manipulate this guy and get him to say what he wanted by rapid firing and kind of confusing him, and so he was able to keep the strong control over the conversation. With an experienced detective or somebody who's been around this, they can't do that. So this wouldn't happen with somebody who was more experienced, which again shows me that the defense is grasping at straws. Their case is weak. When you can't argue the facts against your client, you attack everybody else any way you can. And that's what they're doing, in my opinion. All right. Well, Annette Dare to the next witness. Okay, this was a pretty good witness for the prosecution. He's a friend of John and Karen. So his wife was texting them. They were going to meet at the house. They knew they were coming. He gave them directions on how to get to the house. While at the house, he looked outside and saw Karen and John parked in front of the residence. He looked out 4 times because they never came in. So the defense's big thing is he was in the house, everybody beat him up. Since this guy's a friend, so far the defense has not got one person to say that John was ever in that house. Not one. I know all the conspiracy people. They're all lying, Rick. He was in there. They beat him up, and they're all lying really good. I don't believe that. And this guy's a friend. He's got no reason to lie. Their kids play together. He kind of respects John. He liked John. And his wife and Karen were kind of semi-cordial, and they would meet and do things and go to sporting events with their kids and stuff. So the defense is going to have a hard time discrediting him. But he looks out 3 times or 4 times in a window. The first time they're parked in front of the house. Second time he looks out, they've moved forward and stopped again. Third time he's looked out, they've moved forward again, which is close to where the body was found. And then the 4th time he looks out, the car's gone. So did the accident happen then, or did they drive around and come back? To me, this stopping and moving indicates they were arguing. They stopped. She didn't want to go in. He wanted to go in. They argued. He was like, I'm going to go in. Then she finally said, let's just leave. They started to leave. He said, no, stop. I want to go in. And she said, I don't want you to go in. Whatever. They were arguing. And then they moved a 3rd time. There's no other reasonable explanation for them to move and stop, move and stop, move and stop. The most likely thing is they were arguing. And then they left, and he never went in the house. So they're going to question him tomorrow, and we'll see what he says. This was day 13 of the trial. This was a pretty good witness for the prosecution. All right, we'll end that there. Till tomorrow, day 14.